Gotcha. Aaron Chetley, 24 DCCR 0776.
Quick note, when you hear reset, it means the case isn't ready yet. Both sides need more time to review evidence or negotiate a plea. It's common, but too many resets can signal a defense strategy or delays the judge doesn't like.
This is Miss Malfino's case. Aaron Chetley. Good morning, sir. You're Aaron Chetley. And Mr. Chetley in 24 DCCR 0776 is charged with assault, family violence by impeding breath or circulation. And what is the announcement?
Judge, we just need a reset. We're still going through the discovery in the case. So if we can just have a little bit of time to finish that.
It looks like you guys were hired. Yeah.
Quick note, when you hear reset, it means the case isn't ready yet. Both sides need more time to review evidence or negotiate a plea. It's common, but too many resets can signal a defense strategy or delays the judge doesn't like.
Just hired August 20th, it looks like, so, okay.
For the next topic, for sure. I've already sent him everything. I want to make sure he feels like he's got it.
Okay, I'll just do a normal reset. Mr. Chetley, make sure you stay in touch with your attorneys and they'll let you know when you need to be back. Y'all can also visit about all the information that they've received and what any options are. All right? Thank you. You're free to go. Thank you, Mr. Walker.
Max, you good?
Yes, sir.
Judge, I'll translate with the court's permission.
Okay, thank you, Mr. Rojas. Sir, are you Juan Martinez Rodriguez?
Yes. Yes.
And Mr. Rodriguez, in cause number 25 DCCR 0017, you're charged with a third-degree felony offense of theft of property, and that's from
10 years on the line, and here's the twist. The defendant just rejected a plea deal that could have wiped this felony off his record.
September 12th of 2024. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes.
And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 5-year deferred probation, which means if you successfully complete that probation, you would not have a felony conviction on your record. You have every right to reject that offer. I just want to make sure that you understand what the possible consequences are if you're found guilty and what your options are if you wanted to plead guilty. And do you understand all of that?
Yes.
And do you want to reject that offer and have your case set for trial?
Yes.
All right, I'll get it set for trial. I want to also make sure, Mr. Rodriguez, that you understand that after today, I will not accept this plea agreement. Once your case is on the trial docket, if you change your mind, you can enter a plea to something different or go to trial and have a jury decide. You understand?
Yes.
And you're appointed, correct?
No.
Okay. All right, then Mr. Rojas will begin preparation for trial.
Thank you.
Thank you. And you also have Eliza Riley.
Yes, ma'am.
Eliza Riley. Good morning, sir. You're Eliza Riley. And Mr. Riley, in cause number 25 DCCR 0380, you're charged with the third-degree felony offense of deadly conduct discharging a firearm. Are you sick? Are you sick currently? I can't hear you. Are you sick?
No.
Then pull that down so I can see your face. Stand up. So you're charged with the third-degree felony offense of deadly conduct discharging a firearm, and that's from December 21st of 2024. Your indictment alleges that you were previously convicted of possession of a controlled substance, third-degree felony, in 2011. And what that means is if you go to trial in this case and you're found guilty and that prior conviction is true, the range of punishments between 2 years and up to 20 years in prison. Do you understand?
Yes.
Speak up.
Yes, ma'am.
And I have here on,
I know there's a rejection that's been signed in this case. I'm asking we don't set this case for trial yet. There's a
Judge West gives one final grace period, but make no mistake, her patience has limits. This is a quiet before the storm as the courtroom shifts toward more serious cases.
witness statement that contradicts a lot of the facts that are alleged. I need to look into that before we set this for trial.
okay, so why don't I just delete that and let's reset it one more time and for y'all to do that. So Mr. Riley, before I set your case for trial, it sounds like there's some more discovery and evidence that needs to be looked at. So I'm going to do one more reset for everybody to look at all of that. And when we come back, if there's still a rejection and we need to go to trial, then we'll get it set at that point, okay? Stay in touch with Mr. Rojas. He will let you know when you need to come back. You're free to go. Thank you. Mr. Samuel?
Yes, Your Honor.
On Julia Schultz?
Yes, Your Honor.
Good morning.
Good morning. She's present.
All right, you're Julia Schultz, and this is 24 DCCR 2290. What is the announcement?
Judge, if we may, just have one final reset. I have no reason to believe that we don't have the case disposed of. There's a hearing tomorrow down the hall in family court that will get some finalized paperwork signed, et cetera, that I need to make the offer of extended, but I don't have any reason to believe that we're not going to work it out.
Okay.
That's my understanding.
Obviously, it's been going on for quite some time, so
Yes.
this will be the last reset. Something needs to get worked out before that, by that next court date.
Will we?
Okay?
Okay.
Stay in touch with Mr. Samuel. He'll let you know when you need to be back.
Thank you.
Thank you. Good morning, you're Maverick Neal. And Mr. Neal, your attorney, Mr. Doyle, is out with some health issues and will be for some time. He's asked that I reset your case. I want to ask you if that's what you want me to do, or if you would like me to consider if you could qualify for a court-appointed lawyer so we can get your case moving. You can wait. So what did he say? I know, but time-wise,
Surgery's in November.
that's what,
I forget how long.
I know.
Yeah, but it sounds like it's major.
Yeah, that's what I'm concerned about. Yeah. Okay, so Mr. Neal, I'm going to reset your case until the first of the year. And so you need to stay in touch with Mr. Doyle. You need to be talking to him, get in touch with him, continuing, if y'all have a contract, pay him, whatever you need to do, and then we'll see where everybody is in January. If at that point he's unable to be back, then it will be time for you to either hire another lawyer possibly, or us look at a court appointed, okay? Okay, you're free to go. You're free to go, sir. Thank you. See, is Mr.
If you're enjoying this look inside real courtroom moments, take a second to subscribe and turn on notifications. Every week, we break down the most compelling hearings, rulings, and real reactions straight from the courtroom. No filters, no edits, just reality and law at work.
A long-lasting full moon.
Good morning, you're Charles Guidry. And Mr. Guidry is charged with theft of property in cause number 23-41646. And Ms. Norman, where are y'all on this?
So, Judge, we have all the discovery, we have an offer. There's some restitution involved and some other minor things that I'd like to be able to talk to Mr. Coleman about to try to see if we can resolve this without me placing it on the trial docket.
Okay.
But I'm certain it's gonna be a plea, so if we could just reset it for a plea, and that'll give me time to talk to Mr. Coleman.
Sure. And it looks like you were just...
Mr. Smith, but
Yeah, maybe he'll work on that with you this morning.
People don't talk to me when I first.
Whoever thought somebody would say that about you, Mr. Smith? Just kidding.
we go way back.
All right, so, and it looks like you were just hired in August. So
Yes.
we'll just do a normal reset to give you time to talk to Mr. Coleman and see if y'all can get that worked out. Mr. Guidry, stay in touch with Ms. Norman. Once she gets all that information, you guys can go over and see what the outcome will be, and we'll get it taken care of at the next court date. All right, you're free to go.
Thank you.
Thank you. Let's see, Matuska. Good. All right, sir, you're James Rucker.
Yes, ma'am.
And Mr. Rucker, in cause number 24, DCCR 1348, is charged with violations relating to hazardous waste and... It's a third.
Mark Garcia.
The punishment range is that of a third-degree felony in that one, which is between, if you're found guilty, between 2 years and up to 10 years in prison. Do you understand? And then in cause number 24, DCCR 1349, you're charged with theft of property. Which is a state jail felony, and that's from May 18th of 2022. And then what that means is if you get found guilty in that case, the range of punishments between 6 months and up to 2 years in a state jail prison. Do you understand? In each of these cases, I have plea bargain rejections here with your signature on them and Mr. Galmore's that shows that the district attorney's office has made offers if you wanted to enter a plea of guilty in your cases. In the violation of relating to hazardous waste, they've offered, it looks like, is that a 6?
Oh, no, I didn't put the year, sorry, Judge. It was short.
Talmore.
The deal was for a short term of deferred.
So it's for a deferred probation that would be up to me, and I guess, which is obviously you've gone over with Mr. Galmore, type of probation where you don't have a felony conviction on your record. And then, is it the same in the other case? So you would be, if you wanted to plead guilty, it would be deferred probations in each of those cases with the term and how long that probation is up to me with input from everyone, of course. You have every right to reject those offers and have both of your cases set for trial. I do want to make sure you understand that what your possible consequences are if you go to trial, what your options are if you wanted to enter into those agreements. And do you understand all of that? And do you want to reject those agreements and have your case set, both cases set for trial? All right. And is there any reason, I mean, obviously, I can't imagine that the offer would get better. Ms. Malfino?
It's a Mr. Shearer's case, Judge. I don't have any reason to believe that that offer would change. I know they've discussed it for quite some time. I want to
Yes.
make sure that it's on the trial docket that hits the peer review.
So I do typically make sure, unless there is new evidence that comes up that either Mr. Galmore or Mr. Shearer does not know about, or something has changed, I will not accept these plea agreements after today. And so if you change your mind later and want to enter a plea of guilty, it would be to some other plea agreement or open to the court or something like that. Do you understand?
Judge, just for the court's perspective, this case had a restitution in the amount of approximately $100,000. That's been reduced to approximately $13,000 now that those financials have been sorted correctly.
Okay.
I believe this is a situation where it'll either require trial or it would be dismissed for restitution.
Okay, so not a restitution paid out over probation. Okay, all right, then, obviously, if that happens before, then the cases get dismissed, and that's another way for them to get off the trial docket, but other than that, we'll let a jury decide. All right, you're free to go, I'll set it on the trial docket, thank you.
Drayton Rose.
Good morning, sir, you're Norbert Freelo Jr., and Mr. Freelo is charged with murder, and Mr. Galmore, Mr. Nichols, what's the announcement?
Judge, I don't think we're ready to set this for trial yet. I know it seems like every hearing I tell you there's stuff we need to investigate and find out, and there is still in this case. There's a potential witness who has given unsworn statements that is basically blown off appointments to give a sworn statement, and we need to run her down.
That's what we were going to do last time.
And they made appointments, and she didn't show up.
Well, if we're talking about
Here's where it gets complicated. Norbert's charged of murder. Yeah, he's on house arrest with a GPS tracker. The judge refuses to remove the monitor, but loosens restrictions for him to work.
that one witness, she did meet with the investigators between.
Okay.
But there's also a new witness, another witness.
Okay.
And possibly some video footage that was deleted that I believe the Port Arthur Police Department is trying to get their hands on.
And I need to check the status of the subpoena for that video. We need a little more time to it.
Okay, all right, we'll just do a normal reset. Y'all can work on that. We'll see where we are at the next court date. Mr. Freelo, make sure you stay in touch with, did you have something
Yeah,
else?
I could, yes, Judge. I don't have a motion necessarily on file, but Mr. Freelo currently is on house arrest with a GPS device. His wife has recently been unable to return to work to the federal prison, so their income is limited. He's trying to find a job. It's been difficult, obviously, with the thing hanging off of your ankle and whatnot. So we were asking the court if the court would consider removing him from house arrest and GPS requirement.
No to both of those things, but potentially to, the GPS is going to remain on. I would consider, Mr. Nichols, what's your position with regard to him looking for work and getting a job?
I'm in favor of that, Judge. But I agree with the court. I think the monitoring needs to stay in.
For now, at least,
Monitor moving from house arrest?
Mhm.
Okay.
yeah. Wear long pants and cover it up, whatever you need to do. But at this point, I'm not willing to do that based on obviously the nature of the offense. And so if you do this, Mr. Galmore, if you'll just send maybe a memo over and copy Mr. Nichols on it so that I have a paper trail to say that you asked me and that I granted that part of it, and I'll just sign off on a memo. Doesn't need to be a motion.
We'll do
But
that.
that'll just remind me to get it in the file so that it's clear. Also, we can send that to whoever has his GPS monitoring device so they know it's just for work-related purposes. You can go find a job, go to work, things like that, but it's not just a full-on go do whatever you want kind of
Well, Judge,
release.
actually, that's currently the status. He is allowed to leave only for work purposes currently. But because his wife is unable to work, her medical conditions made it much more difficult for them. So if the court would still consider just removing him from house arrest and keep the GPS, that would probably help a lot with the other life's necessities.
Okay. I know you've asked for him to drive her to this, there's been
Yeah, he
doctors.
went to the airport the other day. But I mean, obviously in life, a lot of things like that pop up regularly, and if he's gonna wear a GPS device, the court will always know where he's at, that's important. But removing him from house arrest would be probably a big help.
Mr. Nichols?
Hard for me to really argue with that reasoning, Your Honor.
Okay, so I am going to require for you to remain in Jefferson County without permission. So if something happens, like the other day with the trip to airport or whatever, get with Mr. Galmore, he'll send me something, I'll approve or not approve. In Jefferson County, do what you need to live your life. I don't want, that doesn't include going to bars or going out at night
Maybe
or.
a curfew is appropriate, Your Honor, unless,
Yeah, that would be.
if he ends up with a night job, obviously that's different, but.
So let's do this for now. Let's make I'll release the house arrest, remain in Jefferson County with the curfew 8 p.m. to 6 a.m. If you get a job that interferes with, just get with Mr. Galmore and get those hours, whatever the job is, and we'll work around that. But primarily, I want you doing necessities away from your home, and that's it at this point, okay? All right,
Judge.
thank you.
Thank you, Your Honor.
Every case in Judge West's courtroom tells a story of choices, second chances, and the weight of accountability.